Okay.
Let's go a little bit back.
Okay, let's go back. Let's introduce ourselves.
Yeah, like the first one, we will introduce ourselves. So hello to everybody once more, and also to the people that actually are listening somewhere around us. You know, this is some interface that we are feeling. People are behind the screens. So I was coming here scrolling my mobile phone. You know, I was looking for the grades because it's time in Estonia, children are having grades. You know, we have this digital environment for school. So I'm consuming the data, right? And then I'm coming here and I'm trying to have a Wi-Fi password, right? Because I want to have the data right now. I want to have it in my mobile phone. So we are kind of getting the same issue regarding all the legal aspects, regarding trade and the finance. We want to have the data. We want to have it now. So we are kind of like urgent on that. So I remembered from the yesterday's talks that they were raised subject on trust, and they were raised subject on mindset. So I remembered when I was walking here, I remembered one story. Hopefully people listening maybe know. If they don't know, then just to remind that regarding trust and the mindset, if a person goes to the ATM and takes the money out of the ATM every payday, for example, for the pension, just to take it to the bank because it's secure, right? So it's kind of a mindset if the ATM is secure, or is the ATM the same as the bank? So it's kind of a state of mind. If I take from ATM, because it seems to be less secure because it's open for everybody on the street, and then I take the money from it and take it to the bank. So it's the same as a mindset. So it's a little bit introduction of me. I like to have a really innovative mindset. I am a cocktail of risk and legal. Because I have 15 years experience in great institutions, all stuff of legal, like everything, like insurance, litigation, loans, whatever you have, leasing and stuff like that, whatever there is. And on top of this, 8 years in public sector risk management, so aware of digitalisation and all the public sector issues regarding that, PPP projects and etc. So I'm really happy to be here, and really happy if anybody has questions or arguments that we are going to be talking about. So thank you for that, listening.
Yeah, so I mean, you've got two really positive lawyers here, because we've moved from private practice or practice to actually bringing all those skills into businesses. But at the same time, as you say, we benefit from the entrepreneurial mindset that people like SupplierPlus and all the Lever ID and all the other great companies that we work with. So actually, I always say I'm a lawyer by day and I'm ITFA by night, and the nights are very long because ITFA is very busy and very successful, but it's the only paying job I have. It's the only thing I get paid for, being a lawyer, so I have to remember that I have to speak about legal stuff from time to time. It's the less exciting part of what I do, but it gets more interesting when, as you say, we can take that legal training and actually feed it into things that work. Because one of the problems that we have in digitization is that the technology moved really fast and the mindset changed. And of course, here in Estonia, you've had that mindset already for a long time. So the technology's moved very fast. The law has really been behind. Sometimes there are exceptions. I was talking about one of those the other day. But generally, the technology is way ahead of the law. And there are so many things you can do. I was saying to my friends at Lever ID, so much of this technology is scalable and adaptable. What you're doing for bills of lading, what OFA is doing for bills of lading, for example, at Wave, you can use that for promissory notes and bills of exchange and warehouse receipts. So the technology is really a creative tool. And the problem that really we're trying to deal with here is, maybe we'll sit down because it won't get in the way of the screen. But so this is a joint Sean and Airi effort here. So I'm doing the boring bit. I'm telling you about what the problem is, and on the left-hand side of this slide, as you face it, and then there's a solution. So the left-hand side, this is what I call the octopus, the squid. So this is typically the interactions you would have on a typical trade transaction. And as you can see, there's a lot of them. In a typical trade, you've got 20 plus players, 10 to 20 documents, 5,000 data interactions, and those are all sorts of people. They are couriers, shippers, carriers, the ports, the customs authorities. So there's a lot of that, and all of that has to be paper at the moment. It has to be paper if just one of those players or participants in that chain wants to, can only deal with paper. So if you remember the example I gave yesterday, my trip back from Marrakesh, from EBRD, where I had actually a QR code, it had to be printed because that's what the Moroccan airports require. It had to be printed, so the whole thing fell down. So I could get my QR code, my boarding pass on my phone, but then one person needed it in paper, so the whole thing falls down. And that's really why it's so important that the policymakers, the governments, both at the local, national and regional level, and we'll talk a lot about the EU later, where we've all been doing some work. But in Estonia, I'm going to then go on to you, because you're already doing this practically, so X-Road.
Yeah, we have this really marvelous interface, is open source data exchange platform, and actually this is the answer. If I was listening yesterday's talks about the centralized approach, you actually have to centralize the usage of the data, the source from where you can reach to that data that you have. So the data doesn't have to be served in any kind of a centralized server. This is not the right way to approach it, but you can have the data all around the world. The owners of the data can be wherever they are, and you just use the interface to access the data when you need it. So it's the same discussion that we had yesterday, how we actually can solve this kind of issues that the data is all around. We don't want to share kind of the data. Well, be surprised, we actually are sharing right now. If we use our mobile phones, we apply for any kind of assistance from health security. So this is the thing that we actually are doing it right away, and we are in between of choices. To be in more kind of a comfortable environment, we have to share our data, but up to some kind of limit. So we have different regulations on top of it, how we can use the data, how we can serve the data, preserve it, share it. So let's just make the max out of this opportunity. And actually, if that picture on the left seems really, really nasty, it goes nastier if you add some layers into it, like public, private sector, different countries, different counterparties. It goes really nasty. For example, the X-Road is a platform where in Estonia we can approach public services, for example, streaming any kind of data that we need. It's usable for the entrepreneurs, for the private, for the natural persons, for public sector institutions. Everybody can access that. And we have 1.3 rounding there million citizens. So we are talking about a solution that actually saves us 3 million working hours. It actually consumes more than 3,000 services, different kind of. We have 2.5 billion transactions there per year. We are talking about a country that is really, really small. So if you could just consider to put this kind of the left side of the description into that visualization, and to actually put the data in the more compact formula, it is manageable, it's doable, and we are not talking about Estonia only. I've heard yesterday also that Estonia is very in front line with these solutions. Yeah, we are, but let's not forget that actually if we approach the different countries, some similar services already are there. For example, the same X-Road technology is already exported. It's operational also in Azerbaijan, for example, in Colombia, in El Salvador, in Faroe Islands, for example, of course, in Finland, in Germany. So we have more and more in Vietnam, for example. So you actually have this kind of data exchange channels already used, but people maybe don't just know. It's a mindset, it's a knowledge of, do I know, if I go back to that, do I know that actually if I withdraw the money from the ATM, this is the bank that I'm sending my money in the next day, taking the cash there, so it would be more secure. So it's the issue of the knowledge. If I have enough knowledge of which are my opportunities right now. So I'm trying to raise today kind of the question, or nudge you into the opportunities more rather than concerns, because we have different regulations in the EU that are supporting us in the development of the technological, the data exchange platforms, the legal environments. It's just a kind of a mindset for the legal people to actually feel those opportunities there and actually put them into action to support supply chain finance, support whatever the business there is. So let's talk about opportunities more.
Yeah, and one of the things that I find really interesting about your extra slides is that little hexagon there on the left, ERP.
Yeah.
So that's integrated into companies, and that's so it's we talk a lot about and a lot of the focus has been on e-citizenship and accessing public services, but that's the platform, that's the stepping stone to actually rolling this out to companies. And as you say, not just here, but globally. And we'll see this actually has an impact on the sort of legal issues that we need to look at, and we'll look at those a bit more detail. But just to stick a little bit to why it's worth doing this. So this is a study, or these stats are from Bain & Co. And as you can see there, the savings are really enormous if you get it right. So in terms of costs, it's a 15 to 20% reduction in your operational costs, and that's across the banks, the corporates, and you can see there how it all works. But you're essentially reducing all of those vertical boxes. Now, in terms of time, which is really important if you're an SME, it's even bigger savings, 80%. If you go up to full potential, they estimate up to 80% saving in time in getting an import LC issued. So this is a prize worth fighting for, and that's why the law actually, comparatively speaking, has moved relatively fast, and thanks to countries like Estonia.
Yeah, I would add into also that we were talking yesterday that the paper is sticky. We are kind of digitizing the paperwork, but actually it's also important to take into account that we don't have to produce these papers that much. We don't have to produce all the agreements. We don't have to have the signs on every agreement. We don't have to have any document on top of every action. So there is a technology that actually supports us in log files, in the trails that we can follow. And also it means that, for example, if we compare the legal environment to the actual trade that is happening. For example, I agree on some retail big counterparty that you are going to be delivering me on every Wednesday the bananas or oranges or clothes. So I'm not going to be agreeing on every Wednesday on the new agreement or signing separately for those acknowledgements. So this is the thing, this is a framework. And if you can reach the possibility in a legal environment to actually achieve the framework, even if it's with the blueprint, even if, yes, we have to sign at that point or agree on some electronic forms or by hand because the legal environment says that electronic documentation does not exist. But there is still a trail of actions. So it means that if we agree on something, the following actions can be followed by a trail. So, for example, you have delivered me the goods that we have agreed on. So it's an action that has taken place, regardless if there is any paper behind it on that spot. So this is also an issue that if we are reducing any kind of costs, we are digitizing, we are trying to be cost effective. So at first, just think about the trail that you're actually leaving behind today. Do you need all those steps that there is? The kind of an extra layer of security is not actually needed because you have to estimate your risks very rationally. I have been a chief risk officer in Tax and Customs of Estonia. So we had to make all those risk analytics, all the operational measures. We had to understand who is the more risky, the less risky, the lower risky. So we estimated all of this. But you have to be also effective in your actions, what you take. And regarding, I'm reaching out to lawyers for this, that you can also have an extra layer of layers just to be secured, but to stop down the business there, because you have to be confident in yourself, or if you're not, you just reach for it. Ask people, can we do this, or let's have this risk, to estimate the risk and actually to acknowledge that there is a 20, 30, 40% of risk. Let's take it because it's worth it. Let's use it. So the extra layer is not always mandatory. It's not always the thing that supports you, but it holds you down. For example, if you make a trade for 1 billion a year, and to make that trade, you have to put an extra effort every day to sign the papers, to transport them, and etc. Instead of taking that 10% of risk and maybe something happens. So I don't want to be that bold, kind of, but it's the way of forward. So you have to actually estimate the risk and be confident. What is there that we are risking?
And the law has to support that choice. And actually, when you were speaking, you reminded me of something that we're not going to talk about, which is smart contracts. So in terms of automating your actions to the extent, and smart contracts, the joke about smart contracts is they're not smart and they're not contracts. But probably some of you have heard of smart contracts. They're basically automated instructions. So it's sort of if X, then Y. And it's usually about delivering goods or something like that. And people get, a lot of lawyers get very excited about this, and they think that the whole of contract law, which is remarkably similar the world over, is going to be exploded because we're using technology, and that's actually not the case. Some really interesting papers come out in the UK on this, but unfortunately we're not going to talk about that. We're going to talk about the trade instruments. Okay.
Does it go? The battery.
Batteries run
You
out.
always
That's
check the
basic
battery.
technology. Aha.
It good?
Right. Okay.
Yeah.
Yes. So just the cost to paper again, just to hammer that in. World trade 21.6 trillion according to WTO in 2019. If you break down again that sort of octopus, that complicated diagram at the beginning. You come to, or one estimate is that a typical transaction could cost around $80,000 just in trade costs, and that's something where an SME sometimes makes these things completely unachievable. The G7, this is an ICC G7 study about how much money could be released. So we could release digitizing trade if you manage to digitize everything. And this really is a sort of utopia. If you manage to digitize everything, you could increase trade by $9 trillion. That's maybe a little bit of an unrealistic figure because that assumes that everything is being digitized. But even digitizing part of that, even if you could do 25% of that, 20% of that, that's obviously a huge number. Trade costs falling here by 84%. 6 trillion in extra exports. It's a prize worth fighting for. So it's a prize that is in the area of trade is really focused around the trade instruments that we have. So three instruments really that we look at here. And the problem with all of these in trade finance is that they need to be signed and they need to be in paper form. And the reason they have to be in paper form is because of this legal issue that we have, which you don't have with every contract. So a lot of contracts already can be digital. Most invoices are digital. The problem or the specific requirement and the unique thing about these instruments is that possession of them gives you either right to goods, it's a title to goods, or it's a title to a debt, and it's an unconditional title. So if you think of a bill of lading, that actually, it does a number of things. As we say here, it's a you know, it's a contract for the carriage of goods, but it's also very importantly a title to the goods. So you can go to the shipper and you can demand those goods, and the shipper will only give you the goods if you can hand over the piece of paper. And so that's the problem. Is this what we call the possessibility problem? Promissory notes and bills of exchange are very similar. They're not titled to goods, but they are titled to a debt. And what makes them very powerful, and I sort of mentioned this yesterday, the reason they're very powerful, especially in the emerging markets, is that they are one of the few sort of trade instruments or debt instruments that has any sort of real history. Again, because of the sort of colonial era, you've got British and French laws that were left over from that time. And they're understood and they are appreciated and valued. And they have protections that other forms of debt don't have. So I do a lot of work in the Middle East. Obviously a lot of energy being traded there, oil especially. They use promissory notes a lot because it's the best, it's the most legally secure kind of instrument. And one of the interesting things that when we talk about digitization, of course, is that you should be, and we talked a little bit about this, about documents versus data, that you should be forgetting what the document is. But actually, there are some documents that are magic. They have real magic. You know? Yeah. It's like Harry Potter's wand. You wave your bill of lading at the shipper and you get the goods. You wave your promissory notes at the debtor and you get your money back, in theory. So they are magic, and this is why we can't just move seamlessly from documents to data. But we need to try and get the best of both worlds, really, have our cake and eat it, in the words of a British politician.
Sorry, if I could add into it, just a thought that we are kind of stick to the principles that we are used to. So when digitizing or thinking of how we go forward or how we automate the processes, then we shall ask always the questions regarding all the technological developments that we do, all the legal concerns we are facing. We have to raise the question why we do this, why we actually need those documents, or for what are they produced?
Yes.
Because behind every document there's a data. Somewhere is a data, because we don't write them with our hands. We might sign them with our hands, but there is a data in the computer somewhere, right? We are exchanging the data. We are agreeing over the emails. What are we going to do tomorrow? Are we going to sign the agreement? Do you like the agreement? Do you want to propose some amendments? So this is the data environment that we are putting to be kind of a document, a visualization of that data. We already are using the electronic means for it. There is not like it's only paper. It's just if we print it out and we manually sign, it's a paper in this form. But we actually can produce from the data in the system different kind of papers, because we can, put the name on top of it, on lower it, so the text in the middle or up part of the document. So we kind of make out of the data the document that we actually wish to have. So it's just kind of a mindset. Do we have to visualize that? Why we are there, that we actually need that physical thing in our hands. So we always have to kind of ask ourselves, maybe we can skip some steps. I understand that in some environments and legislations there are rules. Of course, we have to have on paper basis. There are principles, for example, the same shipment example. But it's the thing that in general, as was also raised yesterday, it's not the digitizing of the paper, but we just have to have a new approach and an automated way. So I would just add into that the smart contract or the smart way, I think, is the only way forward.
Yeah, that's right.
It's doable.
It's doable. That's right. Through the great technology that exists, it's doable. But we're not going to break away completely from these practices. And I say in some countries they do have real value. So what we're looking at is getting the best. I'll say the best of both worlds, getting the equivalence of paper into digital. And so this slide here just shows you very quickly about the qualities that these different documents have. But remember, the point here is they all have to be paper and they have to be signed. Now, this point about our ambition, Airi, this is the problem, isn't it? So this is a study carried out in Europe to see which documents were acceptable, which documents of the various types there were acceptable in digital form. And you can see that the documents that we're talking about, the bill of exchange, the promissory note, the bill of lading, they either have to be paper or it's unclear, which is just as bad, really. And you've got very few countries where actually they can be paper. So this is the problem, and we'll talk about in a few moments. We'll talk about the work that's being done in Europe, some of the lobbying that ITFA is doing. But this is the problem we need to get over, and this is only in a handful of Western European countries. Well, there's Serbia there as well for some reason, but generally it's an uncertain environment for digital. Okay, so eIDAS. I know this is something we spent quite a lot of time talking about here. This is the electronic signature regulation in the EU, and it's a bit of a model for the rest of the world. But I think the important thing, and Airi sort of mentioned this, is around trust. So what does it? You have to ask yourself, what does a signature do? What's the purpose of a signature? Well, it's generally twofold. The first one is it identifies the person who is signing, so it tells you it's come from person X, and it also, very importantly, shows the agreement of that person to the contents of that document. And of course, both of those things can be problematic in paper form. Signatures can be forged, and you can, especially in the business-to-business environment, you deal sometimes with people who don't have authority, and the laws have developed sort of doctrines around that. Apparent authority, you should be able to trust people, but you're always a bit unclear. The great thing about digital signatures is that you can cure a lot of these problems, because the signature, which very often is not it's not a signature, it's some sort of code or a stamp or something. They will deal with both those problems in one fell swoop. Having said that, there's a bit of a debate, which we'll talk about the kind of signature that you want. So eIDAS sets up this sort of hierarchy of signatures. So at the bottom, you've got a simple signature, and that could be a scan. It could be just typing your name in an email. You type it, and that's identified you, and it's your name, and the email has content, so you've agreed to something, and that works. It certainly works in England, and it works in most countries. In the business-to-business environment, you're normally very happy with that because you trust the person. You have a pre-existing relationship. You then move to the next level, which is the advanced signature, and then the highest level is the qualified signature, and it's only the qualified signature that is equivalent to a handwritten signature, and that's what a lot of people get hung up on. All right, they say, I've got to have, and I find this especially in Germany. I don't know the experience that you've had, but in Germany especially, we're finding that our counterparties, banks and commercial parties, are saying, you've got to have a qualified signature. Qualified signature is a great thing. I know that's what Lever ID is doing. And it's important that you're able to offer that. And as we were discussing, it's important that you can offer that in a very convenient and seamless and as cheap a way as possible. In my own bank, we started looking at DocuSign. So when you move, DocuSign does, which is a well-known signing platform, it does have the ability to give a qualified electronic signature. But to do that, you have to make an appointment with somebody who on a video call, and you have to hold up your passport, and it's this just isn't going to work for trading relationships. So one of the things that's going on is should eIDAS, which recognizes simple signatures but sort of undervalues it and plays it down and kicks it in the pants, should we actually be trying to enhance the status of simple signatures? And what's been your experience?
Yeah, thank you. Yeah, I totally agree that actually we have underlying regulations in EU because we kind of need the joint environment or the understandability. What is the level of trust of how we can approach different counterparties in different countries, in different member countries, and of course, if we go to the third countries, then we always ask, like, what can we do there? Is there an electronic environment and the e-signatures, are they adapted or not? So it's an issue. I'm going back to the question that why we do this, why we sign the documents. I'm taking the example from our own legislation, our own practice, is that we have court practice also on this kind of agreements. For example, employment agreements. If I send over an email to a contestant that actually, you have applied for the job, I like you, the pay is like this, working hours like that, and they say, okay, I come on Monday, yes, come. This is the agreement. It doesn't matter if there is a e-signature or simple or more qualified signature on top of this from the other side and my side. If we exchange from the authentical emails, for example, at SupplierPlus.com. So I'm representing SupplierPlus. I'm making my statements regarding the SupplierPlus. I'm representing them. So we have this kind of practice in place already in EU that actually you don't need signatures everywhere, but you can actually raise different kind of agreements over SMS, over Messenger. You can send SMSs, you can send emails, you can call. Of course, the oral agreements are always like, lawyers don't like that, right? We can do everything with these kind of agreements. But if you have any trail that is physical, some written trail, you can use that. So if we ask for signatures, we have to ask ourselves why we need this, what kind of level we actually need. So if we approach our counterparty that we know, we have used to be working with them over the emails. For example, if a friend or a really nice counterparty, 10 years of experience, sends an email, please stop the shipment because something happened. Would you do that? Or no, I have an agreement on Wednesday, the bananas have to be there. So you actually react to that email because you trust the source, right? You don't need the e-signatures from the member of a board on top of this. So these are very various situations you can handle differently. Of course, if you approach a counterparty that you don't know, you're not aware of, you have just agreed on the shipment, on the conditions, of course you need the level of security there more. So there comes the signatures. Is the simple signature enough or not? So you have to estimate the financial cost, the risk appetite kind of there. Are the products the ones that you have to really reach in a hurry matter, or you have the time to prepare all that? Do you have to have the time to have a plane and meet and make the blue signature? So I think we have lots of opportunities. We just have to kind of estimate the risk appetite we have. Can we take it? Do we need that extra layer of security on top of this? And I'm still stepping into the digital world, saying that how we do nowadays, like how we do in SupplierPlus, actually how we generate the business relations. This is all smart contracting. For example, for the suppliers, they are onboarded to our platform. We don't even need to sign agreements because we have our own core practice, we have the legislation that actually, if following the digital trail, if the person could not have reached to the spot D mark, not entering from the A and B and C, so it means that, yes, if you're already on the spot on D, it means that you entered from those steps also, it means that you agreed to the agreement. If, for example, pushing the button on the B step, you signed kind of virtually saying, yes, I like the agreement, I will go forward using your interface. So we have also these kind of opportunities, and this is what we do. You don't have to have the signatories, but if you act upon this agreement that you have just signed or been agreed to, it means you are conducting all those agreements. And even if there is no signature on top of it, the trail, the digital trail, the activity that you have been taking, this is the agreement. So let's not forget that there is a physical world we are in, and the digital should support it, not stop it down or make it more slower.
Yeah, exactly. So as I say, qualified electronic signatures are the only signatures that legally are are equal to a handwritten signature, but as Airi is saying, you often don't need that, and the inconvenience of using qualified trust service providers means that it's just not realistic. So, currently there is a review of eIDAS going on in the EU, and this is being done. Really goes back to the point about the sort of the stepping stones. This is really in the context of the e-citizenship project. So something which you already have ready in Estonia, but something which the EU wants to roll out to the rest of Europe. And the issue here really is about how eIDAS deals with documents. So eIDAS is principally about signatures, and signatures are an important part of documents. But as I said, in relation to these important trade documents, there is a sort of magic to the envelope, if you like, a magic to the format, and so we need to deal with that. And we thought that in ITFA that the opportunity, that the review that's going on at the moment, was a good opportunity to get in some reform relating to documents. Now, there is a little bit in eIDAS about documents. It comes later on. And in fact, it comes in Article 46. So Article 46, which says you will not discriminate against an electronic document, not signature, but electronic document in court, has not been successful, as you can see by that ICC study. It hasn't worked, and the reason for that is the very specific nature of these kinds of trade instruments. So it works for a normal contract, for an employment contract. It works for an invoice. It works for a contract to buy a car, for example. But it doesn't work for these very specific and very important trade documents. So we've been lobbying in Brussels. This is what we have suggested. So there's a recital at the beginning, but Airi has kindly highlighted the important things here in the amended Article 46. So this is drafting that we produced together with the Law Commission of the UK. I'll talk to you a little bit, we'll talk a little bit later about what the UK is doing, and it's not because I'm an English lawyer that I'm going on about English law. It's that English law is very important in trade. 80% of trade documents are governed by English law, even if the cargoes will never reach or touch England. So the Law Commission, which is the body that's responsible for reforming the law in the UK, has come up with some proposals which we'll look at later. So I did this drafting with the head of that project, and you can see, to get back to the point, that we should be what we're striving for here, and what all the UNCITRAL laws, all the e-commerce laws that have been around for 20 years that have inspired eIDAS, what they're all doing is they're trying to get equivalence. It's nothing more complicated than that. It's just saying whatever you can do on paper, you can do digitally. Now, how you achieve that, that's where some of you guys come in. You have the technology. You have to have, as we'll see in a moment, reliable systems. So there are certain standards. And of course, the market will decide who has the best system, right? Is it going to be Lever ID? Is it going to be somebody else? That's the market share that you're trying to capture. But the law enables this to happen. So the law is an enabler here. It's not giving you the market. It's enabling you to enter that market. So you can see the important things here is the document, if made in electronic form, enables. It has to be capable of being possessed. So how do you possess? It's easy to possess a piece of paper because I can hold it. How do I possess an electronic document? It doesn't exist. It's intangible. And that's been the problem with the law, this problem of possessibility. This is where the systems come in. But the law has to recognize that system can give you possession. And then possession of that document is satisfied by having control. So a little bit circular, but basically anything you can do, if you look at the beginning, any document or instrument, when in paper form, entitles the holder to claim performance, shall be valid and not denied legal effect and admissibility as evidence, if made in electronic form that enables it to be exclusively possessed. So it's all about equivalence here. And this is what we are proposing to the EU. They're very interested. They know the problem. They know the gains, the gains in trade, the gains in extra liquidity. They know the gains in operational savings. And unfortunately, it's a little bit of a sideshow at the moment, because I say this is mainly about e-citizenship. But they know the problem. They're interested. The proposal has gone out already for the revision, and it doesn't at the moment contain our proposal, but they are actively looking at it. So it's not the end of the road. This is about simple versus qualified signatures. And maybe, Airi, do you want to talk about this?
Yeah, regarding the legal requirements, it's you can follow the expectations of the counterparties. So if there is a free will, for example, I'm going to be agreeing with you that we are going to be using the simple signature, I think we should take it like the regulation should support a situation where we don't have any agreements regarding that. So if we have agreements on usage of the simple signature, it shall have the same effect as we could use the qualified signature. We also trigger the kind of a problematic situation of identification, because we cannot also forget about the people behind those agreements, so how we identify them. So we have software also in place for that. So if we use the right means to identify people, then we shall have the opportunity also to use the simple methods to do digital approach to the agreements, right? Yeah. So it's a matter of, do I know the people? If I don't know, how I identify the person? So, and if there is a possibility to use a simple signature, why not to use it? So it's the same, yeah. And if eIDAS will come forward and saying yes, it's allowed, you can go to court with that. There is no kind of a restriction regarding that. Yeah. It's very welcome. So I really like that proposal that have been made, published. It's not. I know it's under negotiation. It's not like the thing that is coming a certain date, but I really expect that it will be applied in the near future, because I'm going back to the childhood. I think that everybody of you in the audience have been knocking on the friend's door just to find out if they're all at home. You know, you were going around the village or the country or the city, wherever you were raised. So you were knocking on the doors, and you didn't have the phones, right? Some of them didn't have phones even. So we were knocking on the doors. It took us a day or half, you know, just to find out if we can go outside and play. So nowadays it's like, I have two children, two childs. I have one is a teenager already, so I couldn't imagine if she or he couldn't call to friends, like 30 of them. So, are you at home? Shall we play? And it takes like 5 minutes, right? And the rest of the day you can use that to play. So this is the same comparison. Actually, we have to enhance the time that we have, the way that actually we give the means, the digital means, we approach also in the regulative measures, just to give the time for the business, right? We want to make business. We have to have the data. We are keen to consume the data. So.
Yeah, we're keen to move trade, and we're keen to trade. Going back to some of the points we made yesterday around attracting new investments. So this is one part of it. So this is what's going on in the EU, and it's really important. The EU, I have to say, is lagging. It's a little bit behind the rest of the world, and sort of this is what the rest of the world is looking at. This is MLETR, Model Law on Electronic Transferable Records. And this is the inspiration for the English law, which is not just an adoption of MLETR, but has the same effect. It's also the inspiration for everybody, because actually, when you look at this, I go back to the basic concept in the reform of trade digitization laws, and that is functional equivalence. So don't discriminate against paper. It has to be equivalent. You have to deal, obviously, with the issue that you can't possess a piece of paper, and you deal with that through the system. And this is really what the MLETR is doing. It was published by UNCITRAL, United Nations Commission on International Trade Law. That's an executive body of the UN. They're based in Vienna, and they publish and have been publishing. They publish laws on all sorts of things, but they've been publishing e-commerce laws for more than 20 years now. And as I said, you see the influence of this, and they're really a great body for codifying or standardizing law across the world. But in the case of MLETR, this has been a real success story because this was published not that long ago. And it's already, as I'll show you in the next slide, it's already been adopted by quite a few countries, more or less without amendment. And that's very unusual within the course of less than 5 years for model laws to be adopted so quickly. So it's a real success story, and it's an inspiration for other countries. So people sometimes say to me as a lawyer, because I work in a global bank, Sean, is there a world law? Does world law exist? Why do I have to know what the law is in Vietnam and in other places? Why isn't it all the same? It isn't. We all know why, but the frustration of bankers and others is that they want this uniformity, and this is what the UNCITRAL, what MLETR really tries to achieve. The very last point here on this slide is it's the reliable system that's important. And what is a reliable system? Well, in Singapore, which is one of the countries that's adopted MLETR, you actually have to be licensed by the government. It has to be an approved system. That's how they decided to do it. In the UK, as I say, we're not adopting MLETR, but we're effectively adopting the same philosophy. The reliable system is left open to the market to decide. So how will they do that? Well, there are certain this sort of guidance or indicators in the English draft law that tell you what to look at. But whether or not you achieve that is something you will have to show as a matter of fact. So this is where the opportunity comes in for for the likes of Lever ID and others, and for SupplierPlus and all the tech companies that are playing in this space. And that's the important thing. That's the translator of paper into digital. No discrimination, but you've got to deal with the fact that you can't hold a piece of paper. So you've got to have some means of translating the possessibility or creating that possessibility. And as I say, it is through this reliable system. Now, the new legislation is very simple. This is an extract from, or the way you can change the law is very simple. This is an extract from the draft UK law that's been presented to Parliament. It was in the Queen's speech. That's the speech that marks the beginning of each new UK Parliament, in which they present the laws that will be voted on. And subject to whatever else happens, we hope that it will be adopted this year. It's a non-political bill. It has all those benefits that I've already spoken about. But you can see there just how simple it is. The effect of anything done in relation, look at C here, anything done in relation to an electronic document that corresponds to endorsement or the equivalent trade document in paper is by virtue of this law valid. It's really, and the whole act here is like a page and a half. MLETR is slightly longer. But the actual legislative change, really very simple. I've been asked to say a little bit about URDTT. We're getting down to the last 5 minutes, and Peter will probably start waving at me soon. URDTT, so the Uniform Rules for Digital Trade Transactions. So, one of the other approaches to getting global law, to getting standardization, is that we adopt a common set of rules. And of course, we've done that for UCP, for letters of credit. But we have to remember, they are a set of rules. They're not law. And in fact, if you look at UCP or you look at URDTT, there's no law in them. There's no governing law. So they will be the law that decides the governing law, or the provisions that decide the governing law of a document that incorporates them. That will depend on the local law. All right. So, and you can put it in there. You can specifically say it's subject to Estonian law or English law. But all of these rules, they're just things that you incorporate into your contract. So they're another set of contractual provisions. This one is new. The point here about URDTT is that and this is published by the ICC. I sort of helped with some of the drafting, but it's essentially an ICC publication. It follows and it's inspired by what UNCITRAL have done, especially by the MLETR. And the important thing here is that they are to be used between the commercial parties. So they're not primarily, unlike letters of credit, they're not primarily about banks. They're primarily about the relationship between a seller and a buyer. And if I go to the next slide, you have to incorporate them into the contract. And they do really two things. Firstly, they say all the records, all the proof that I need, I will show you digitally. So the documents become records, and they are transmitted digitally. They're received digitally. They're checked digitally. And hopefully, with the systems that we now have, that will be an automatic sort of matching process. If you remember one of the slides I had yesterday in my SCF presentation was about that matching engine. And once that's done, there's an automatic payment obligation that is given by the buyer. So documents have been delivered. I say unconditionally I have to pay, very much like what happens in payables finance. And then a bank can add effectively its guarantee or confirmation on top of that. And this is how it works. You know, it's conditional or unconditional. If it's conditional, i.e. you're waiting for the documents, then the documents are received, and it becomes unconditional. The payment obligation comes into being, and the bank can guarantee that. Rule books, just quickly, and then I'll pass back to Airi. Rule books, again, a sort of private law. We have WAVE here, who have an important rule book. That's the basis on which currently bills of lading have to work because of those different functions, including the fact it's a contract and it's title to goods. So effectively, it has to be a contractual workaround for that. We hope that with digitization and with the changes in the law, that actually we'll be able to get away from that. And I'm working on some stuff at the moment with a Swiss fintech where we are trying to really, what we're trying to do is commercialize promissory notes. This is a fintech that does a lot of business with energy companies, and I'm very hopeful that actually we don't need a rule book, and we can just put the necessary provisions actually on the buttons, on the functions. But currently, this is the way that a lot of these systems have to work whilst we wait for MLETR and so on to come into effect. And the problem here is, again, goes back to what sort of digital commercial environment are we going to have? Are we going to be looking at a couple of platforms, or is it going to be an open ecosystem? If we're reliant on rule books, we're probably more likely to have a few platforms because people don't want to go through the fuss of constantly reviewing new contracts. If we're in an environment where the law allows instruments in pure digital form, then you don't need a rule book, or you need less of a rule book. It becomes much simpler. Okay, Airi.
Yeah, thanks. So we are a little bit going over time, I feel that, because I couldn't do it like in 10 seconds. I will try, but it's really hard.
We started late.
Yeah.
Maybe you give us a few minutes? Yeah.
I'm just
okay, great.
making the citation from Lauri Lusti from Digital Logistics Center of Excellence yesterday. I was writing it down. It's they are coming. They are still studying, but coming. I think it's a sentence that we actually have to acknowledge, that if we don't do it, they will do it, like the younger ones, the smarter ones. So I would enhance things here just to wrap it up. If you could come here, thanks. Just to wrap it up, the invisible documentation that has to be there. This is the way forward. So just, is that actually new for us, like conducting the agreements online? even if the underlying agreements are not online, they are on paper, as just have been explained, that there are regulatory means behind that. Even if the underlying documentation is on paper, we can finance, we can support the business still, because we can conduct these kind of business decisions online. We can conduct different kind of agreements, the supply chain finance agreements online. We can make these kind of things. The payable finance already enables to receive any financing, right? Even if you have paper underlying transactions. So conducting the agreements online is very important to acknowledge that you don't have to make every agreement, but you can agree on a framework and then go forward just acting by the framework agreement. For example, if we are signing the claims to finance them in the supply chain finance, it means that we actually don't draft every assignment agreement, but it kind of generates in automated way on the platform, for example. So this is the thing accelerating. Pre-filled tax returns we have in Estonia, of course. There are more countries that are approaching this, already having at least half. So we already are using the data the way that actually we don't even put the data into the system, but the system tells us, is it the correct data? Just submit yes on top of that, and everything is accelerated even more. So let's use that, the opportunity to actually pre-fill everything that we can. The AML, KYC, we want to actually pre-fill them, right? We don't have to go like how many dollars it took to make KYC, AML checks on one person in UK.
Well, at my bank, it's $40,000.
Yeah. So we could estimate all the trade kind of if you do everything manually, checking. So this is the automation we really need. E-invoicing we have been talking about. This is the metadata. We use the metadata. We just have to agree on the data. What kind of data we actually need? It also concerns trade finance. Regarding trade, what kind of data you actually need to have to obtain in order to finance, for example. What you actually ask from the counterparties, from the buyers, from the suppliers, what you actually need to acquire in order to provide the financing. Where is the risk appetite? Where is the secure limit for that? So do we really have to approach all the documentation regarding that some of them are on paper-based? So there is a sustainability agenda. The sustainable environment, I think, is the most important. And now I am really approaching to the legal people, to the lawyers. I know that there are lots of them. I'm really happy about that you approached us and you have the possibility to take part of the summit. Is that the sustainability doesn't mean only in the trade, that the trade has to be kind of green or sustainable or whatever happens, the chain shall continue, but also the support for that chain. It means that actually the legal people, even if there is lack of regulations, there is opportunity to actually make the best out of it. So I've made some of the examples. So I'm really reaching out to the lawyers just in order to support the sustainable trade. We have to support and foresee the possible risks or foresee the opportunities. Approach our IT team, our IT colleagues saying that we should have this or that because it's simpler. Don't wait if they come to you saying like, I need your input. Can I do that? Do I have to put this and that sentences? So this is really a kind of a cooperative approach to that also. So let's please see the opportunities, not only obstacles on top of that. So if we invest into technologies, there are lots of things that we have to acknowledge before, because you are going to make these kind of approaches that I want to have this platform or develop it further, and then you change it back because you didn't think it through. You have the opportunities there. You have to put the checklist on top of it, saying that why we do that, do we actually need that? So let's really cooperate with legal also, because the legal environment is there already. It's the matter of knowledge and the matter of the approach, the risk appetite.
Okay, I think we're being told to wind up, so.
Okay, we will wind up. So the key takeaways is that they are approaching. Our generation is expecting this from us. We are expecting this from each other. So let's cooperate. Let's find the ways forward. And also regarding every digitalization and the paper-based things that we still have, let's ask a question. Do we need all that?
Yeah, totally agree.
Okay, so
Right.
Thank you.
That's it. Do we have time for questions or no?
Yeah, let's take a question. If I haven't looked at this to see if there's any. Sean, do you want to see if there's any questions? I haven't. But very interesting, and you're absolutely right, Sean. You started late, so therefore it works out. And actually, it's a very good introduction to our next speaker, who is patiently waiting for us. But I was just going to ask something while you're looking at that, Sean, and that is, one of your earlier slides was about trade documents that were acceptable legally. And I noticed bill of lading in all the countries that were listed on the left-hand side of that slide was pretty much not acceptable. And I wondered, Sean, if under MLETR, which interesting, which jurisdictions have adopted that and will be adopting it soon, might that lead to a situation? It seems to me that if bill of lading becomes acceptable in a digital format, then other things will roll on from that and the whole thing will accelerate.
That's right. So, I mean, bills of lading are the ones we focus a lot on because they're so important in international trade. And, you know, most, I think, what was it, the figure that we had from OFA yesterday, 80% of, is that right, 80% of trade goods that are shipped cross-border go by sea. So it is really important. It's also the one that we have a lot of data on. But again, I go back to this point that these are transferable records. So actually it's very generic. The law is generic. And the technology, importantly, is very generic and capable of being used in a lot of different situations and for different instruments. And that's one of the great things, one of the great areas of promise. This is where we can make a difference for our children, because we have that technology and we just need to apply it to the right business case. I don't know. Do we want to take any of these questions, or?
We have wonderful questions, and I know that there are representatives from the banks here. So if you could just take it, we could just approach saying like, yeah, we like it, but we cannot answer it. It's, do you think that strong customer authentication, as defined in the PSD-II, can be used as a simple signature for opening bank accounts, which requires more comprehensive identification while onboarding?
Yeah.
So this is a question for actually credit institutions, because they are like, under them is lots of regulations saying what you have to do in order to open bank accounts, fight with fraudulence, fight with terrorism, and et cetera, et cetera. So if we are to answer that, I would answer that if you have authenticated a person face-to-face, for example, is the best way. You are you and you sign it, of course it's okay. But if you don't know the person, you have to follow a kind of agreed line in authentication process. So it means that you actually have to be aware that in internet you can be whatever you want to be. I can be a man if I want to, right? So yeah. It's a harsh question. It's a good one. Actually.
It's a good question, and I think but I think you made the important point. It's about regulation. So in the retail sector, there is an extra layer of regulation, which is in relation to this. It's about strong customer authentication for retail bank accounts, and it goes back to the point that you've made very eloquently about trust. And so simple signatures, yes, can be part of that process for opening a bank account, but you need a lot more. But you don't, as far as I'm aware, you don't need to, as an account opener, you don't need to have your digital signature validated by a trust service provider. I don't think you have to do that. I think the regulation and the requirements of that, as you say, extra ID, seeing passports and so on. Sometimes it's easier, sometimes it's harder. I opened an account on Revolut 3 or 4 years ago. I was amazed how easy it was. I tried to open an account recently with Chase and it was a lot harder. So these things change all the time, but this is all about it's all about the regulation on retail banking. And that won't apply.
Airi and Sean, I'm going to have to be the bad guy.
You're going to be the bad guy. Okay, so we won't answer the second one.
Yeah, we would have answered that,
okay,
but...
Yes, okay, well, all right. Whoever asked the second question, which is about regulation, isn't an obstacle, please come and speak to us. Are there any parties that can be helpful but are too passive? Well, that's not SupplierPlus or ITFA, I would say. We're very active.
We are very
So
active,
on that
yes.
positive note, I think probably Peter wants us to get off stage.
Okay, thank you very much, Sean. Let's just show our appreciation.